Chapter 4, Law, the Courts, and Contracts. And this starts on page 75 of your textbook. The important learning outcomes for this chapter are to understand the basis and primary sources of law, identify the classifications of law, and we're going to define the following concepts of torts and discuss how the tort of negligence affects healthcare. We are going to list the 4 essential elements of a contract and differentiate between express contracts and implied contracts. We are also going to compare the contractual rights and responsibilities of both the physicians and the patients. Here are a list of the important key terms for Chapter 4, and we are going to go over all of these. As you might remember from all of your years in education, we have 3 branches of government. So we have the legislative branch, and that's the Congress, and they're the House and the Senate. Those are the ones that write, debate, and pass bills. And then we have the executive branch, which is the president. Executive orders become law without approval of Congress, so basically the president is making their own decision. However, that interferes with the checks and balances as far as Congress goes. And the president is what I call the figurehead, since the president continuously changes, whereas people in Congress, the Senate and the House, they might be there for 30 years, 20 years. So those are the people that we really need to be concerned about, because a lot of the issues that Congress deals with affects regular people, but they don't know what it's like to be a regular person. Maybe they might have at first, but after you've been in Congress for about 30 years or 20 years, their income bracket is different and their reality is different. Also, they have healthcare given to them, so they don't have to pay for it because they are in Congress. And we have the judicial branch, which is the Supreme Court, and they are the ones that interpret and oversee laws. So they interpret all the laws of the land. So if you have an issue in Kentucky, you'll go to court. If it's something that's going to affect more than just you, it may be everyone in Kentucky, it might escalate to the Kentucky Supreme Court. And then after that, if it's something that might affect people nationwide, then it would actually go to the federal Supreme Court. And the outcome of that ruling would decide what is going to happen with everyone in the U.S. So that's what happens with abortion. That's what happened with the bathroom bill. I don't know if you guys remember that, with transgender people wanting to use the bathroom that they identify with. And some other people had issues with that. So those are some issues that went to the Supreme Court. So state government has the same 3 branches, and they have the same job, except the executive branch is the governor. So they're the head of the state. But same with the judicial branch, they oversee state laws, and the legislative branch, they have responsibilities to deal with the state, but not on a federal level. And they write bills, they pass bills, things like that. They send it to the governor for approval or for it to be vetoed, which just means the governor will reject the bill. 5 types of law. So we have constitutional law, and those are laws that are based on the Constitution. So like the right to bear arms, that's based on the Constitution. Case law is set by legal precedent, and if you remember, precedent is a case from the past that's going to tell you the outcome of the current case or other cases in the future. We have statutory laws, and those are enacted by state or federal legislators. So basically, Congress is writing a law or creating a law, either on the state level or federal level. And then we have administrative law, and it's enacted to define specific agency powers. So if you think of the CDC or OSHA, the IRS, SSI, basically this type of law tells you exactly what the certain branches of government will do, what their powers are, what their limitations are. And then we have common law, which is law that was originally formed in England, but it's unwritten. So it's things that we sort of expect people to do or not to do. So it's like you don't want to push somebody down. It's deemed rude to spit in public, unless of course you're sick or something. But those laws that we expect people to abide by that aren't written anywhere. It's not a formal rule. You won't get in trouble really if you do it. However, in some states you do get in trouble for spitting, or you could. It's still written on their books, but it's just how we commonly want society to be ran. Classifications of law. So we have substantive and procedural. So substantive defines and regulates legal rights and obligations. So basically it's the law and it's like spelled out word for word. You know exactly what you're supposed to do or not supposed to do. And then procedural defines rules used to enforce substantive law. So basically it's like punishing somebody or ensuring that people follow the law. So if somebody steals, the law will say, you know, it's wrong to steal, blah, blah, blah. And then procedural would be the procedure the law enforcement has to follow in order to enforce the substantive law. Classifications of law. So there's criminal law, and that's law involving crimes against the state, which would be like burglary, or it would be like rapes, murder. Civil law involves wrongful acts against a person or their property. And so people can sue another person, a business, or they types of criminal law. So we have felonies, and those could be punishable by death or imprisonment in a state or federal prison for more than 1 year, whereas a misdemeanor would be less than 1 year and it's a less serious crime. So a misdemeanor could be like a traffic infraction, running a red light, things like that, not stopping at a stop sign. And felonies could be the more serious stuff, such as child abuse, um, burning a house down, embezzlement as far as like stealing money, drug dealing, tort liability. So a tort is a civil wrong committed against a person or their property. And somebody might end up being injured, their property injured or damaged. Or you could be depriving someone of their civil liberties. So that would be like, you know, kidnapping somebody. And it could be intentional or unintentional, depending on the situation. So a tortfeasor is a person that's guilty of a tort. So, for example, we could have a car accident, and the car accident would be considered a tort. Now, the person that might have hit you during the car accident, the person that caused it, would be the tortfeasor. Intentional torts. So we have assault, and that is threatening somebody or causing fear in them. We usually use assault and battery together in layman's terms, so we usually get it confused. But as far as the law goes, assault would be like the threat. Battery would be when you actually touch someone or spit on them or hit them in some sort of way that they don't want. Conversion would be taking someone's property and pretending it's your own and maybe trying to sell it. Deceit is lying on somebody or on something. Defamation would be telling lies about somebody's character. False imprisonment would be a false arrest. You can't just, you see somebody doing something wrong, you can't just try and arrest them as a citizen. Those are the jobs for the cops. Or false imprisonment could also be like kidnapping somebody. Fraud, and if you remember, fraud is a tort, but intentional deceit has to be taken into account, because usually when it comes to fraud, people will say that it was an accident or they didn't know that something was going to turn out a certain way and it wasn't their fault. But fraud is like where you know they did it on purpose. Maybe you have it on tape. An infliction of emotional or physical abuse, that is also a tort. Interfering with somebody's contract, maybe lying or trying to steal money from someone during a contract, trying to have somebody falsely sign a contract when they don't understand what's going on. Invasion of privacy, so That could be going in someone's mailbox. It could be checking their emails, hacking into their emails, hacking into their phone. Misuse of legal procedures. So that could be like someone that lies to the cops about a situation that never happened. And they're basically wasting time and money and energy and lying in a situation just because maybe they want to get back at somebody. A nuisance, that could be if someone's drunk in public or blasting music really loud. And trespassing is going onto someone's property when you're not supposed to. An unintentional tort, that is what we consider negligence. So it's when a healthcare practitioner fails to exercise ordinary care and the patient is injured. So basically, this healthcare practitioner did something wrong. And if you think of the case where those nurses held in the baby for Caroline Malatesta while she was in labor and giving birth, so that would be considered negligence. So also, we can charge an institution. So in that situation, some of you had written in a discussion post that they wish the hospital was also charged. And a lot of people like charging the medical facility besides the doctor or nurse, because with some damages that you can claim, you can get more money depending on how much the person makes. So of course, if it's like a medical assistant or a nurse that does something, you will get less money than if you're suing a whole corporation. Evidence of medical malpractice would be expert testimony. And so that person wasn't there usually, but they are somebody that can speak to the situation that happened. So with Caroline Malatesta, basically any other nurse or a physician could basically tell you what should have happened. Clearly, no one should have held the baby's head in while she was giving birth, no matter the circumstances. So that would be the testimony of an expert to say what should have happened and what was wrong in the situation. We have to follow the law, so that would be federal and state laws, hospital bylaws, so what is normal for that hospital setting, what are the rules of the hospital, what are their practices and procedures. We have to think of the customs and community practices, so what's normal for the community, and then accreditation standards, so what does the Joint Commission say as far as delivery in a situation. And we know clearly it would never say that to hold a baby's head in while a woman is giving birth. The court system. So jurisdiction is the power to hear a case. So basically, it would be like, does an Indiana cop have a right to arrest somebody in Kentucky? Like, it's out of their jurisdiction. Now, the Indiana cop could call a Kentucky cop and say, hey, somebody's speeding over the bridge, they're being really reckless, they're drunk, or whatever it is, and have a Kentucky cop arrest them, unless it is causing imminent harm at the current situation. And imminent means that, like, someone is about to die or something crazy is about to happen, that where we can't wait for a Kentucky police officer to come to the scene. So it would be the same thing when it comes to court cases and judges. Like, do they have a power to hear a case? Do they have a power to make a decision in a situation? Is it under their authority? And then for federal courts, as far as their jurisdiction, it would be antitrust, federal crimes, also fraud with Medicare and Medicaid, and that's usually what you'll see more of. You might have already seen it depending where you work. If you work in a convalescent hospital or hospice, any of these geriatric places, as far as the elderly goes, you might see some of these things. So when it comes to Medicare and Medicaid, some companies or pharmacies even, or pharmacists, people that work for these places, they might bill for things that aren't currently happening. So they might say maybe 10 patients had an MRI and bill Medicare for it. However, usually the government doesn't really check when it comes to these things. It would be pretty impossible to check on everybody. So it's just like it's paid out and it's almost automatic. But maybe only one patient actually had an MRI. So I usually say if somebody's really good at their job, they probably know how to cut corners or cheat the system in some way. And that's what some people do, even though they work in healthcare. And as far as the state courts go, it's slightly different. So they deal with local issues, going to trial, appellate courts, and the state Supreme Court. On page 87 of your book, it has a figure of the court system. So you might want to check that out. If you ever have to go to court, or if you're curious about a certain court case, you can look at that chart and see where they might go to court. So some people have to go to court for their taxes, not paying their taxes. So that would be U.S. tax court. There's a military court. So there's courts for everything. Players in the court scene. So a plaintiff is the person that's bringing the charges. They are considered the victim in a situation, the one that's saying that something bad has happened that shouldn't have happened to them. The prosecution is where the government is the plaintiff in a criminal case. So that could be in a situation where a lot of people are being harmed by a product. So I believe I mentioned before the birth control issue where a lot of people were ending up with blood clots. So in that situation, since so many people are being harmed, the government could become the prosecution and take over the case, because it's easier for the government to fight a large company versus a single person. They might not have the money or the resources, and then the government is saying, well, so many people have had blood clots, it's costing everyone money, it's costing lives, because, you know, people die quickly from blood clots. They usually aren't discovered until it's too late, so the prosecution would take over the case. And then we have the defendant, who we're saying did something wrong, so they have to defend themselves. They have charges brought against them in a situation. Essential elements of contracts. So in order for a contract to be valid, 4 elements must be present. It must be agreed upon, and it can relate to now or the future. People have to agree to it, so it must be communicated. It must be in good faith, so it can't be a joke. It can't be under stress, like having a gun to someone's head to force them to sign a contract. It must be understood completely, and it must be defined. Like, what's going to happen, what exactly does this contract entail? And also, we have to have consideration. So something of value must be bargained. Maybe it's payments, and then there's legal subject matter, and that basically means that it's legal. It's for legal purposes. So a contract could be voided if, like for the instance for Love Robinson, so Malachi Love Robinson, since he wasn't really a physician, and someone signed a contract maybe to pay him, then the contract will be void because he wasn't really a physician. Or the contract is broken somehow by the physician, like maybe they did something wrong, maybe they harmed the patient, operated on the wrong side of the body, so the patient wouldn't have to pay, and that would void the contract because the physician breached or broke the contract. And then it has to be contractual capacity. So basically the people who are part of the contract have to fully understand. So you can't sign a contract with a minor. You can't sign a contract with someone that doesn't really speak your language. You can't sign a contract with somebody that's elderly and maybe experiencing dementia at the time. So those are the elements of a contract. Types of contracts. So we have express contracts and implied contracts. So express contracts are like spelled out. They're written or oral agreements in which all terms are explicitly stated. So we know exactly what this contract entails. And then we have implied contracts, where it's unwritten or unspoken agreement whose terms result from the actions of the parties involved. So for an implied contract, you can think of going to the doctor. So it's implied that you're going to use your health insurance, but if your health insurance doesn't cover something, then it's implied that you will end up paying because you probably signed for that before, but maybe you don't sign for it each time you go in. Termination of contracts between physician and patient. So some people get upset when physicians no longer want to see them or dismiss them, but it is their right, since it's their job and they have a right to be comfortable where they work, and their clients or their patients are their customers, so they have a right to not serve somebody, especially if these things have happened. So the patient never pays, so everyone wants to be paid for the job that they do. If the patient doesn't keep appointments, continuously, like they're like a no-call, no-show, that becomes annoying and wasteful. Maybe someone else could have had that appointment. If the patient doesn't follow the physician's instructions, so it's one thing to talk to your physician and say, hey, I really don't want to try this medication, or I tried it and I had a bad reaction, and it's another to completely ignore the physician or lie. And also, a patient seeks services of another physician. So most physicians want you to get a second opinion, especially if it's going to be surgery or something serious, like a serious diagnosis. However, if you think of pain management, things like that, like a person can't go to one pain management physician and then just expect to go to another and that not be flagged. Laws governing payment for fees of service. So third-party payer contract. So the example from the book is this woman named Susan. She goes visit her aunt at a state. She gets sick. She goes to her aunt's doctor, and then the aunt tells the office that she will pay for Susan's treatment. And so the aunt might have to sign a third-party payer contract. Then there's Fair Debt Collection Practices Acts, and that means that the debtors have to treat you fairly. They can't harass you. They can't tell lies. They can't threaten you or give information that's incorrect. And then there's implied contracts, and that would be like if you go to see your doctor, as far as getting your medical treatment covered, or as far as paying, then it's implied that you would pay later for whatever your insurance doesn't cover. And then there's managed care plan contracts, and that's with your health insurance, and they would basically cover a certain amount depending on whatever your health insurance is, and you have to pay them, and then you also have to pay the hospital or doctor that you see. Rights of physicians. So they can make reasonable limitations on the physician-patient relationship. So if a physician has been dealing with your family for maybe 20 years, 15, 10 years, they might invite you to their child's graduation, but it can't be something where like you just show up at their house because you Googled them. So the physician has the right to make limitations on the relationship if that's what they want. They can work with whatever credentials that they have. They might be certified or educated in maybe 10 things, but they might only want to practice 4 because maybe they don't like the other things. They can determine their office hours. They can specialize in whatever they'd like to. Of course, they have to go through a fellowship for that. And they can decide what services will be provided and how they will be provided. Patients also have rights, so they have the right to be spoke to considerately and respectfully. They have a right to know their diagnosis, treatment, and prognosis. So the prognosis is basically what their future will be like living with the illness. Is it something that can be cured? Is it some type of treatment they have to take to slow it down? They have a right to informed consent, so they need to know what type of medication they're going to get, what type of medical treatment they're going to have. They also have the right to refuse treatment. I know some people say that you can't refuse to take this medication or whatever if you're in the hospital, but you can. It's your right. It just has to be documented in the patient's chart that they won't take this medication, and then you have to say that you told them what could happen if they possibly don't take it, but it is their choice. Confidentiality, of course, following HIPAA. Continuity of care, so if they go to the hospital and they have something wrong, they have the right to continue their care, to receive treatments, and they also can know the knowledge of hospital rules, especially if something bad is happening. They might need a patient advocate, they're treated unfairly, so they have a right to know all the rules of the hospital. Implied duties of a patient. So it's important to follow the physician's instructions and to cooperate with them, to talk to them about medications or your concerns with your health condition. Also, you have to give all the relevant information to a physician to form a diagnosis. They don't want to be missing pieces of the puzzle. And then sometimes you might have an adverse or negative health reaction when it comes to something, but it won't be the physician's fault because they had no idea. It's important to follow physician's orders for treatment and to pay for any services that you receive.